So the first card that I have is for Dave Wilcox.
He's about to.
Okay, I'll take him.
So.
So he's here, so I'll just
Yes.
move his card. Okay, thank you. So Casey Stilson.
I was gonna say.
Good morning.
Good morning, how are you?
Yes,
Good.
thank you.
Okay, great. So Dave Wilcox is also on the board of directors, but I'm Casey Stilson. I'm the general manager of Safety Harbor Club. I'm gathering information for the board of directors and the membership. Several of the townhomes in Safety Harbor Club are across the street from LCEC's lot. So we are interested in the proposed project's environmental impact, including flooding and appearance of the lot and screening. So we wanted to stand on record for future speaking. Okay, thank you so much.
The next card that I have, I apologize if I don't get this. It's Jonathan, and then I cannot quite read the last name. Is it?
It's Flight, F-L-I-G-H.
Flight. Okay, thank you so much. And your Peggy is on the same. Did you both wish to speak?
I have to speak for her. She's not here today.
Okay, thank you. Good morning.
Good morning. My name is Jonathan Flight, and I'm here to speak on my behalf and some other folks' behalf. Of course, my wife, Peggy Clancy Flight, is part of the same presentation that I'd like to cover here. We are asking for the denial of the rezoning of 4510 Hodgepodge. We are longtime residents of North Captiva. Our address is 161 White Pelican Drive, North Captiva Island. Before I go into my words, I'm going to speak on behalf of some of my neighbors, the first of which is Mr. Thomas White. A message to this group is, my name is Tom White. I'm a full-time resident of North Captiva Island. I've owned property for years. I reside at 4501 Oro Pesos Lane, and the proposed lot to be rezoned to be commercial is what I see outside my kitchen window, and it is presently an eyesore with cables and equipment. And I have such a small lot to build any structure. It is just a small lot to build any structure that really obstruct my view, and it will distract from the aesthetics of the island and distract from the main drag of Spanish gold. There are other commercial real estate tucked away for sale that will not be in view all day of the homeowners and the visitors. He's sincerely and strongly asking not to rezone the lot. Thank you, Tom White. The next individual is J.D. Porter from North Captiva. I'm just going to read down their comment. There are approximately 300 homes on private land. About 50% of the island is state park and conservation land. It is accessible only by boat or plane, no bridges or roads. And there have been recent rezoning attempts, which are strongly opposed and ultimately withdrawn due to the incompatibility of the Lee County Comprehensive Plan. Our neighboring islands, of course, are Sanibel and Captiva. The causeway to Captiva was built in 1963, implemented by strong land use regulations, and nearly half the island is protected by wildlife refuge on Sanibel. Captiva is more commercially developed, includes South Seas Resort and a 330-acre mixed-use commercial property. There are various trajectories here for home density and barrier island development trends, which are on the rise. Local case comparisons. Figure 8 Island started with custom homes in the 1960s, now a gated and luxury development. Captiva Island allowed early commercial zoning and now includes substantial hospitality and retail. Sanibel, Florida, also enforced strict development controls while it's under its causeway, when the causeway opened, and limited vertical and commercial expansion. Upper Captiva, currently residential with conservation easements and a limited use commercial zone, already exists and is available for utility or service use, making rezonings unnecessary. It is precedent setting. Even limiting utility zoning creates a precedent for additional commercial requests. There's alternative availability. Limited commercial zone already exists on Upper Captiva, and commercial land is also available on Captiva. Infrastructure strain. Rezoning encourages development that increases demand on ferry service, waste systems, and evacuation routes. Historical trend. Limiting commercial zoning also leads to limited commercial zoning often leads to broad commercialization on barrier islands. There are some community opposition quotes here. We're happy, but it's going to be a long while before we unwind from all the tension that has caused the community. And that's Van Hammond, one of our residents, after the commission voted against rezoning another residential parcel to commercial. Another quote, our economy is on the island is tied deeply to the health of our environment, and the planned changes would jeopardize our small town feel, increase traffic, and complicate hurricane evacuation. John Lai from Sanibel and Captiva Chamber of Commerce. There's a various table here for Upper Captiva, Sanibel, and Captiva for zoning status. And the final takeaways is Upper Captiva is one of Florida's last low-density barrier islands with no bridges, roads, or resorts. Even limited use rezoning may encourage broader commercial rezoning over time. Commercial zone land already exists. There's no necessity for converting residential parcels. The island's character, ecological integrity, and community quality of life rely on maintaining current zoning protections. And that's from J.D. Porter. Now I'm just going to go to my comments and give you my side of my view of the situation that we find ourselves in. And for the second time in recent years, the residents of North Captiva are fighting against inappropriate development. Rational alternatives to commercially zoned parcels have been suggested, but none have been accepted by LCEC. Instead, LCEC has pursued a concept that is contrary to the principles of land use and violates the lead plan adopted by our county commissioners. Again and again, we have tried to find a way out of the differences between ourselves and LCEC, but it has been in vain. We've been forced into a disagreement, and we are called to meet the challenge of a principle which, if it were to prevail, would be fatal to the orderly development of our community and sweep aside both the Lee County Code and the protection of our island's environment. The LCEC principle of this rezoning, when you strip it all disguise, is surely the mere primitive doctrine of corporate might makes right. That's what the principle is here. And for the sake of all things that North Captivans hold dear, it's unthinkable that we would not meet this challenge. The LCEC request to rezone is completely inconsistent with the zoning plans that the Lee County put in place for North Captiva. Our existing zoning plans were well thought out and based on good land use planning. Unfortunately, LCEC is not only attempting to change our island zoning, they violated Lee County Ordinance 09-8, which says that except for emergency events, community needs, and permitted heavy construction equipment, internal combustion-powered vehicles are banned from pathways on North Captiva. It's difficult to understand why an electric utility company fails to recognize the requirement of electric vehicles on our island. It is also unfortunate that LCEC commenced the clearing of 4510 Hodgepodge without the proper approval, and LCEC has been cited for this violation by the Lee County Code Enforcement Department. Lee County and the Florida Fish and Wildlife Commission protect endangered species. A gopher tortoise study and a permit should have been obtained before LCEC carried out the clearing and development of 4510 Hodgepodge. And these violations were witnessed by many islanders, and it is therefore difficult to understand why Lee County could safely assume that LCEC would study and comply with our county and state law. Florida Statute 163-3208 says that local governments are permitted to establish land development regulations that include standards for siting electrical substations. And under 163-328, there's actually a process prescribed for substation approval. And that law requires that the utility shall consult with local government regarding the selection of a site. The utility shall provide information regarding the utility's preferred site and as many as 3 alternative available sites, including sites in non-residential areas that are technically and electrically reasonable for the load to be served, if the local government deems the siting of a new electrical substation warrants this additional review and consideration. So my question here is, has this been done? If no, why not? And if it has been done, the island residents should see the results of this step in the approval process. Once again, the state law and the process should be followed. My next comments deal with traffic. LCEC representatives at our last meeting stated that there is no traffic on North Captiva and that there is no need for a traffic impact study. LCEC is attempting to dodge the requirement for a traffic impact study. There is heavy traffic on North Captiva. LCEC has the responsibility for maintaining traffic safety on North Captiva and for conducting a professional traffic impact study. There appears to be an incorrect assumption that just because North Captiva does not have county or state maintained roads, that there is no traffic laws, and no reason to make sure that LCEC's development does not make our traffic issues more dangerous than they already are. All the easements which created the roadways on North Captiva give the public the right to travel on them by motor vehicles. Electric golf carts and heavy construction equipment are both classified as motor vehicles. The Florida Statute 3166402A covers traffic enforcement. And it says that the several counties of the state shall enforce all the traffic laws of the state, wherever the public has the right to travel by motor vehicle. And therefore, for the past 2.5 years, I have been working with island homeowners who provide golf carts with their rentals, Boats and Fun, a company on the island who also rent golf carts to island visitors, and the Lee County Sheriff's Office to raise awareness of the unique traffic issues on our island. And this has put me in a position of knowing the island's most serious traffic safety problems. And I would be available to discuss these traffic safety problems with LCEC or anyone so there is a clear understanding of these dangers. And they include numerous unlicensed, underage children routinely driving golf carts. And this is consistently being done in violation of golf cart rental agreements. I have found that many of these children are less than 10 years old. Driving under the influence. North Captiva suffers from vacationers who think it's okay to drink and drive on our sandy cart paths. And there is extensive golf cart traffic that is moving at high speed, suddenly encountering heavy construction equipment at our many blind corners. And 4510 Hodgepodge is close to several blind corners. Turning once again to the question of rezoning, just simply the rezoning of 4510 Hodgepodge, I would say to my fellow islanders that there has never been a time when an absolute guarantee against bad development decisions and habitat destruction could be given to us. But I have hope and a certain sense of confidence that if we all do our duty, if we all look at all the options, and we seek out the best arrangement, then we can once again protect our island home. Thank you.
Thank you. Thank you for coming today, sir.
Well,
Oh, yes, could you provide a copy to the court reporter of the statements that you read into the
yeah,
record?
I'll give it to you. Yep, sure. I'll give them all to you. You can have them now. My statement plus
Yes,
the two others.
yes, to make sure I got it all
Yeah.
right.
Thank you, sir.
Do you want your envelope?
No, you know.
Next, I have J.D. Porter.
So, Mr. Flake covered that one.
That was
Okay, that was one. Thank you. Okay, and Max Forgy. Good morning.
Good morning, Madam Hearing Examiner.
I'm getting there.
All right. While we're waiting for that, I have a report and I have a slide presentation.
Okay. Are there copies for me?
Most certainly.
Thank you so much. Thank you.
Max Forgy, doing business as Forgy Planning in Cape Coral. My address is 236 Southeast 45th Street, Cape Coral 33904. I have appeared numerous times in the past as an expert witness. Briefly, I have a master's degree in public affairs from the Indiana University School of Public and Environmental Affairs. I am a 32-year member of the American Institute of Certified Planners. I ask that I be accepted on that basis. Thank you. First of all, I appreciate the fact that we have an opportunity to speak without time limits. Many places we don't get that opportunity. I will try to keep my comments brief. However, I do have a slide presentation. I have provided you with a report. I know that the Lee County Hearing Examiner's Office always actually reads these things, and again, I appreciate that.
For one moment, I think the applicant had a question.
I just did. Is it possible? Do you have a copy for us? Thank you very much.
Most certainly.
Appreciate that. Thank you, sir.
Thank you.
Appreciate it.
My client is Lacey Farley and the Guardians of North Captiva. And this is a quasi-judicial case. We understand that the decision is going to be based upon the facts. I have prepared for this hearing by reading the staff report, visiting the site, and preparing the report.
Just, and not to, did you have opportunity to review the transcript from the first hearing as well? So you've seen the applicant's presentation?
I did not read the transcript, but I watched the whole thing.
I just want to
And
be sure you were up to speed on things. There were some things that were said at hearing that weren't in the written staff report, so I wanted to be sure you had that information in your comments.
all right, and I do refer to several of the things that my client group raised at the original hearing, and which Mr. Flight just also added. And they are in the written report. Am I pressing the wrong place? How do I advance this? I'm sorry.
I can do it from here.
Hmm?
No, I can't. Okay, give me a minute.
Had a number of technical issues this morning.
Well, maybe I can remove other stuff. Just gonna,
Can you get it to advance from there, Sharon?
no, I can't. There's several other presentations here. I'm removing them. Maybe that works.
Is the battery? One minute. We've had a number of technical issues this morning that we've been battling. Thank you for your patience.
Yep, no problem. If need be, I can make a presentation without.
I think we just need a moment. His slides aren't progressing either, it seems like. Thank you. Yeah, we don't even need
There.
Thank you.
You don't have the remote anymore?
He's working on changing
Oh,
the
change
battery,
the
but
battery, okay.
if you want to wait, or you can start manually progressing and then here we go.
Looks like help is on the way.
It's working.
It worked, Maria.
Oh, it didn't?
Yeah.
Yeah.
Oh,
We fixed it.
Oh, well. Thank you.
Thank you, Maria.
In this presentation, I'll be speaking to the local conditions, which you've already heard much testimony on. I have a few site photos that illustrate the neighbors' concerns. I will review my own recommended findings of fact, which are based upon my research and the testimony which you have heard from my neighbors, my neighbor group. And there are 8 of those findings of fact, and 2 of them are so important that I will read a couple of paragraphs into the record. This is the site. It is surrounded on 3 sides by existing residential. It has been scraped. There's a lot of vehicles and materials on the site. The blue house, which looks right down on the subject property, is owned by Ms. Farley, who has testified. This is a beautiful neighborhood. Always enjoy coming here. Now, you see ponding This was taken last week when I visited. It had not rained in a few hours. I've been here to Upper Captiva a couple of times in the last year, and ponding is a serious problem. Ponding. And here is a view of the spools and vehicles and other items. I refer to it as an eyesore. I think it is. And the neighbors have testified as such, including Mr. Flight just a moment ago. If living in my modest home in Cape Coral, I were to wake up and see this next door, I would probably freak out. I would consider it inappropriate. If my view was on the second or third floor, like Ms. Farley, I would definitely freak out. And I mean, this is the incompatibility issue in one photo. The first finding of fact that I recommend is that the proposed use is incompatible with the residential character of the neighborhood. This is a quiet, low-density residential neighborhood and it will be disrupted. It violates North Captiva's protected character and tranquility. We urge you to deny the application based upon Objective 26.1. And which refers specifically to Upper Captiva. Objective 26.1, preserve the traditional character, scale, and tranquility of the North Captiva community by continuing to limit the densities and intensities of use and development to sustainable levels that will not adversely affect the natural environment or overburden the existing infrastructure. Second, this is a violation of the density limitations under policy 1.4.2. This is a less than a quarter acre lot, 0.24 acres, and it's proposed for a much higher density and intensity use than you have now on the site or that you have in the neighborhood. It will include, if approved, housing, storage, and office in a single parcel. It exceeds the outer island's approved density of 1 dwelling unit per acre. And I'd like to read the proposed finding, which appears on page 7. Policy 1.4.2 clearly limits future residential development to 1 dwelling unit per acre on barrier islands. The applicant proposes to introduce what is functionally a multi-use compound of administrative offices, equipment housing, and worker accommodations on a 0.24 acre lot. This scale and intensity violates both the letter and intent of the density cap. Finding number 3, again, you heard from Mr. Flight earlier, but you heard at the earlier hearing noise, light, and operational impacts. That includes golf carts, which I have observed. There is constant equipment activity in a quiet zone. It's there now. This will result in more night lighting generators and workers who will disrupt neighborhood life. Madam Hearing Examiner, you expressed interest in these issues at the last hearing. I do not see how those have been adequately responded to. We urge you to deny based upon this finding. Number 4, environmental harm without review. There was plenty of testimony at the last hearing. I didn't observe this activity, but the site was cleared before there was an environmental assessment. That's unacceptable. Gopher tortoise habitat was harmed, probably eliminated, and tree canopy was, according to the witnesses, destroyed. This undermines the idea of public review of ecological standards, and it causes us to question the validity of the environmental findings that their consultant made. Number 5, lack of utility and wastewater planning. I have not heard testimony as to where the wastewater will go. I am hoping that this will not be approved in the absence of those determinations. We urge you to deny based upon those findings. Finding number 6, no demonstrated need. There are 220 electrical customers on Upper Captiva. It is clearly approaching build out. I don't know how many more units will go in there, but I do not see evidence that there is a genuine public need. Things seem to work okay on the island without this facility. And strong local opposition has been expressed. It should be considered. Number 7, unresolved hearing examiner issues. I have already addressed that. Use type, utilities and stormwater, no revised plans have been submitted that I've seen. With all respect to staff, they recommended approval, and they gave you, they cited several Lee Plan policies, which were for the most part the ones that we have cited. They reached a different conclusion than my neighbor group and I have reached. I say that with great respect to the professionalism of this staff. I did not see them mention policy 5.1.5, so I want to raise that. And I'm going to read that. And I got this straight from the county's website last week. Protect existing and future residential areas from any encroachment of uses that are potentially destructive to the character and integrity of the residential environment. Requests for conventional rezoning will be denied in the event that the buffers provided in LDC Chapter 10 are not adequate to address potentially incompatible uses in a satisfactory manner. This is a concern. I think this in particular and Objective 26.1 in themselves justify outright denial of this case. I'm not going to do any more reading. I'm going to close. This Upper Captiva neighborhood is one of Lee County's jewels. It has the most amazing balance that I have ever seen of residential use and enjoyment with a natural setting. The neighbors, my clients, obviously value and cherish this amazing resource that they have. They have invested heavily in it. If this were on a bridged barrier island, it might be acceptable. If it were to happen in my own neighborhood, it probably wouldn't. It would probably be all right, although I'd really want them to take care of that debris that they have on the site now. But the balance is so delicate on Upper Captiva that I cannot imagine this succeeding. There are alternative sites that are available. They were, you have testimony to that effect in the earlier hearing, and there are other options available to them for the housing part. You have testimony from the neighbors that they very much respect and value the services that LCEC provides. This is certainly not a personal thing, but they also value and cherish what they have, and there has got to be a better way. Madam Hearing Examiner, that concludes my remarks.
Thank you. Thank you for coming today.
May I ask a couple questions?
Yes, you can.
All right, thank you. All right, Mr. Forty, just a couple clarifications I want to ask you. So number one, you had some testimony about the clearing of some of the vegetation on site, and I just want to make sure you're not offering ecological or environmental opinions, you're just offering planning opinions, correct?
My testimony is land use and I'm not an environmental planner at all.
All right, thank you, sir. You also talked a little bit about density, and I think you mentioned the caretaker's residences. I just want to ask, have you reviewed 34-2 of the Lee County Land Development Code and the definition of a caretaker's residence?
I have read every caretaker's, at one time in the last few years, writing land development codes for other communities. I've read all of them.
Okay.
I do not specifically remember this one at this time, but yeah, read them all.
All right. Did you consider in your analysis that the Lee County Land Development Code provides that a caretaker's residence is measured in intensity, not density, when located in the code?
I do not recall that.
All right. I had just a couple other questions because you talked about policy 5.1.5, and can we agree that the parcel in question is currently zoned RS1? That's the existing zoning on the property today.
Yes.
Okay. And if you look at, in the Lee County Land Development Code, at the permitted uses, schedule of uses in the RS1 zoning district, can we agree that an essential service facility group 1 is an allowed use today in that zoning district?
Yes.
All right. Thank you, sir. That's all I have.
Thank you.
Leave that there.
I still had for Dave Wilcox. Was he back in there? Yes, sir. Morning.
Thank you for hearing me today. My name is David Wilcox. I'm a 40-year resident of Lee County and business owner in Lee County. I've lived on the island for 5 years. After being here for 5 hours this week and last week, I'm not going to bore you with how beautiful the island is, how natural it is. I'd kind of like to say everything that guy just said is, I don't have a slideshow. But I guess instead of doing that, I'd like to kind of address LCEC, not just the council necessarily, but the powers that be. Here we are. I'm sure there's going to be big meetings and reviewing this. And LCEC, for years has actually used Safety Harbor Club's property to store all their stuff. I think correctly, you've identified, especially with the new projects you have out there, that you're ramping stuff up and you might need more space. I agree with that. The problem kind of came with, I'm sure, as the process went out, you bought a personal property, a non-zone property. You made a mistake of buying something that has a septic tank situation where it's actually owned by your neighbor who's objecting to this. So you have a building problem. I know you've talked to Safety Harbor about that. I think that there's capacity issues. I'm not speaking officially of that, but, and so you still have a building problem there. As a business owner, I can't just piss off my constituents and think that that's okay. You can do that and get away with it because it's, so, my plea to the powers that be is really, I think this should be relooked at. There's still very viable properties, commercial properties with adequate space and done right. Maybe we can turn this whole thing into instead of a meeting where Fox News is saying how bad you are, into saying something like, hey, they've addressed this, they found this, and they agree and as a public thing. Maybe we move forward and you can regain any lost capital and expenses of what you've done. You still have the property, you can sell that, so that's a wash, as a businessman. And we move forward and everybody's happy. So that's really all I have to say. Thank you for allowing me to speak today. And again, I hope that you reconsider. Thank you.
Thank you for coming today. Okay, so that was all the cards that were new for today. The cards that I had from last time were, the first was Casey Stilson.
I spoke, thank you.
Okay, thank you. You know what, I think that if that's the case, give me one moment because I think these got switched. All right, I'm gonna call the cards just to be sure because we had two separate stacks, but now these have all got things on them. So Jonathan Flight, you spoke today. Dave Wilcox spoke today. J.D. Porter, that was the letter that was written into the record, correct? Ann Carolyn Taylor.
I believe Duncan Rosen spoke for Ann Caroline
Okay.
last time, so that
Okay, but
she
she's,
could be entered in.
so she's not here today,
I'm
though.
not seeing her.
Okay. Ed Bowes. Harry Edward Bowes, it says? No? Okay.
Was a letter been read? A letter may have been read for him.
Okay. And Lori Rosen.
Last time, yes.
Georgia Murphy.
She spoke on behalf of Alex.
Okay. And then same, Tom Murphy. I recall that. Okay. So those were all the cards that I had. So is there anyone that's present that wanted to speak that has not already spoken? Okay. So then we will close public comment. We'll come back to the parties for a rebuttal. I assume you're going to need time to collect yourselves before we do that. How much of a break would you like before we start rebuttal? 10 minutes?
10 minutes would be great.
Okay,
Thank you, Madam
let's
Mayor.
come back at 10 o'clock then, and then we'll begin with the applicant and the staff's rebuttal. Thank you.
Thank you so much.
you're back on the record, and we can begin with the applicant's rebuttal.
All right, thank you. Good afternoon, Madam, or good morning, Madam Hearing Examiner. Richard Aiken for the record. So to start with our rebuttal, I'm kind of going to go all the way back to the first hearing and just kind of address some questions that came up at that hearing, and I'll try to address everything. If there are additional things that you believe I've missed, please let me know. So there were some questions in some of the testimony about notice and the information meetings that were held or required to be held pursuant to the LEED plan. So on this slide in front of you, what you see is that on February 25th, 2025, we had a public meeting for the rezone that's required to be held. It was held at the North Captiva Fire Station, which is directly across the street from the site. So we did hold that meeting, public information meeting, on North Captiva. Didn't want to hold it somewhere else, making it difficult for people to get there, knowing the access to the island. We also, and there's some information on this slide that goes beyond what really is in this case, but there's some other meetings. In October 2nd of 2024, there were some meetings that LCEC attended regarding some of the hurricane and storm damage and restoration work that was going on the island. Same in September and December, September of 2023 and December of 2021. And the reason I want to point this out is really because I think there's a little bit of conflation between two issues going on here, all right? What we're here about, obviously, is the rezoning of this parcel specifically. But what we've heard from a number of the members of the public is concern about the level of work going on the island and even on the lot today by LCEC. And to be clear, I want to state this very clearly so there's not any confusion about it, but LCEC has been working since 2021 on infrastructure upgrades on the island. And I actually have a copy of a PowerPoint that was presented in December of 2021 to the members of the island by Tricia Dorn, who's also here, updating them on the status of the infrastructure improvements that were going on. So this is even pre-hurricanes. And ultimately, that was being done because a lot of the infrastructure on the island is aging and getting to a point where there was reliability issues, or we were anticipating reliability issues. And so LCEC has an obligation to its customers and its members to ultimately address those, hopefully before they become a problem, so that people don't experience outages. And we've heard many of the members of the public here say, there's no problem, everything's fine. Well, we're glad to hear that. Ultimately, that's what we want, but there is an obligation to do some work. And so there's been work going on the island, and I'd be happy to provide you with a copy of this for the record, but this is a PowerPoint that just describes the extent and nature and the permitting efforts that LCEC had to go through with regard to much of that underground replacement, the environmental gopher tortoise mitigation and all that. That is not related to the rezoning, I want to be clear. It's a completely separate issue. However, just to sort of provide some context as to how we got here and where we are, ultimately, that was already going on, and then we got two hurricanes, well, really three, but two major storm surge events in not only the Southwest Florida area, but specifically on North Captiva, which added to the already problems that we have. And Ray Boss is here, and I'll bring him up in a minute, but ultimately, most of the facilities on North Captiva are underground. And when you get storm surge, what winds up happening is that many of the underground facilities get water damage because they get flooded, right? And so much of the work that's been going on the island is to fix things that were damaged as a result of storm surge, as a result of the already ongoing project to fix aging infrastructure. And so LCEC did have other places where it was storing equipment. Once the hurricanes hit and it acquired this lot as part of a long-term plan to with the new underwater cable that came onto the island. Ultimately, some of the material and equipment got put on this lot, and I'm willing to acknowledge, and LCEC is as well, that yeah, it shouldn't have happened, but it did, and I can't undo what happened in the past. In LCEC's defense, it was at a time of storm restoration when they were scrambling to try to get things done, and so even though it shouldn't have happened, it did, and had long since planned for it to be gone, but the restoration has been more extensive in many places than they anticipated. All that is different from what we're really here asking for. I understand that the two things get confused and combined, but they're not the same thing. So the restoration activities that have been going on and the planned use of this lot in the future are two different things. I also want to just kind of hit the required community meeting and the public notice. There was a question at the last hearing that we had, I believe it was, I don't know if it was Ms. Farley, but I think it was, asked a question about, we were never, this wasn't properly noticed. We did put the notice and advertised it in the Sanibel Captiva Islander. We also posted the notice on the Avalon Engineering Facebook page, as well as the Upper Captiva Fire and Rescue Facebook district page, or Facebook pages. in order to get plenty of notice out there. The signs were posted out there on site on the island, so the notice was properly provided. It was advertised in a local newspaper of general circulation, and then we posted the signs, and we went even beyond that to try to get actual participation. And for what it's worth, that meeting on North Captiva was pretty well attended. The actual pre-zoning or pre-application meeting, if you will. I will also note that the advertisement indicated, and you can see here we have action requested. You can see it's up here to rezone the subject parcel from RS1 to permit the development of an essential service facility to serve the electric needs of the island. So again, we properly advertised it. An essential service facility covers what we're trying to do here. The schedule of uses contains essential service facility group 1, as I discussed with Mr. Forgy a minute ago. So ultimately, the notice and the advertising were proper, and the signs posted before the zoning hearing, I can actually personally testify because I was up there. They were posted and on site ahead of time. So that's the notice issue. I want to talk about a couple of other issues now. So the septic issue has come up a number of times, and it's come up in a couple of different contexts. Okay, so first of all, the question has been, there was, and I want to clearly state what we said before, and I think it was clear, but I want to make sure everybody understands. When we submitted this application, the original intent, there were some conversations with the condo association whose name is escaping me directly across the street there, and they were indicating that there was capacity and they would allow LCEC to tap into their package treatment facility. No. Please let me finish, right? Okay, so there were some initial conversations about that, and then as we got almost, I think it was a week before the hearing, they came back and told us, no, that's not going to work. So yes, I agree with you. The answer is no. But I'm walking you through. But I'm.
Everyone, if we can, I'm sorry, and Mr. Aiken as well. I need to be able to focus, and when everyone was at the podium speaking, I hope you know and felt that I was giving you my full attention. It's incredibly important to me, so I need to hear what he's saying now. I understand it's a lot of emotions involved, and I appreciate that, but please, if you can continue.
Yes, ma'am, and I apologize. So ultimately, I'm coming back to LCEC had some indication, or at least that's how it's been explained, that there might be a possibility to do that. We now recognize, and did before the last hearing, which we stated, that that's not a realistic possibility, and so that's not going to happen. So there were, and I think some of the confusion, maybe a question you asked, is some of the members of the public indicated that they needed to consent to the septic tank. And so I believe that's what they're referring to, is that if we were going to tie into the North Captiva Island Club, the members of that would have to consent. There's no requirement on the island for other members to consent to us having a septic tank on site, which is part of what now the engineers are designing and going through. And that's ultimately likely, they're looking at several different options, but that's what's probably going to happen. The second thing with regard to septic is that Ms. Farley indicated and talked about her septic system, okay? And just so you know, Ms. Farley's lot, again, is here, and this is the LCEC lot. You did hear from a gentleman who was a realtor on the island, and he explained sort of the process of how these lots used to be one lot, which at one point in time were owned by another couple, and they were split off ultimately in I think about 2001, and then 2016 there was some other action. But so now this lot is one lot, and originally, I want to point out that they were platted as two separate lots. Then they were combined, and then they were split off again, okay? But when Ms. Farley's house was built, the septic tank for her house was built sort of right here on the property line, all right? So part of it's on her property, and part of it's over here on what is the LCEC property. And you actually heard that there's an easement, a 25-foot roadway easement on the northern half of the property, so her septic tank's actually in that easement. Bottom line is that she stated she has an easement for the septic facility, and I think there was a question that you raised about, will they have to show easements on the master concept plan? And you are correct about that. The issue is that easement is not an easement over a stated land area. It's sort of like a right to use the septic tank is what it says. I've got a copy of it if you'd like to see it. But ultimately what it provides is that the owner of Lot 1 shall continue to have the right to use the septic tank to the extent it encroaches on Lot 28, right? And so we've got a copy of that easement. I'm aware of it. It doesn't have anything to do with the request. We're not asking to build anything within the area that the septic tank is in. And once again, that 25-foot road right-of-way that's up here on the northern half of the LCEC property. That septic tank's already within it anyway, okay? So nothing about the request has any real direct impact on that, but I did want to address that since you asked about the easements.
Going back to the septic for a second, so just to clarify that, because that is obviously a finding that has to be considered at least. It's not definitive at this stage because you're not within an urban area, so it gets a little murky under the regulatory framework of the LEED plan and how far you have to go with that. So you don't necessarily have to demonstrate that you have that capacity at this point, but what is the plan then, I guess? If your testimony is that you do not need anyone else's consent to install a septic system on this property, and that would be solely to support the caretaker's residence?
Correct.
And the office, I assume, whatever square footage you've allocated towards those two things.
Correct.
So can you explain, what is the plan that I guess need clarification on that, because there
Sure.
was a lot of testimony that there was some tie-in between this parcel and the parcel across the street. And
Yeah.
what you're saying is that that is a condition, but you've got other options if that's not gonna
Sure.
happen.
So, and what I'll do is I'll bring Brendan Sloan up here because he's the engineer who can actually talk about the septic considerations that have been considered. I will say, LCEC does have the right to use the same septic system as Ms. Farley, but there would be capacity issues, right? And so that's why we've explored a couple of different options there. But Brendan Sloan with Avalon has looked into the potential septic options. There have been a number of different, put it this way, the bottom line is that, yes, there's absolute capacity to our ability to get a septic system. He's consulted with septic experts. What the final design of that will look like is going to depend on development order permitting and all of that. But it's not something that we can't do. It's just the final design will come. So I'll bring him up here to just talk about that briefly in a minute. What I did want to do is I just wanted to point out a couple of things to you. All right, so interestingly, this case is actually a really, the title work for this case is actually very interesting. If you like real estate law, boy, you can really get down into it. So what I'm showing you here is Exhibit A, and this is Exhibit A to one of the prior deeds for Ms. Farley's property, just for reference, okay? And if you look down here at the bottom, what you'll see is that it says subject to a 15-foot easement on the north for road right-of-way purposes and subject to a 6-foot easement on each boundary for drainage or utilities, right? So if we go back to the master concept plan, it would be on the north half of Ms. Farley's lot up here, right, which is where the road runs in front of her house, okay? And keep in mind that these two properties, okay, the LCEC lot and Ms. Farley's lot were one at one point in time, so they had one deed, all right? Then what happened is, we go back, this was in 2001, as you can see up here at the top from the recording stamp. You can see that this was the deed, this is actually the deed where the property was split the second time. So it was platted, recombined, and then and what happened here is, as you can see, I know it's hard to read, but I couldn't get a better copy of it. It says, so this is the LCEC lot deed. It says, subject to a 15-foot easement on the north for road right-of-way purposes, subject to a 6-foot easement on each boundary for drainage and utilities. Okay, so it's the same language that you saw from the other deed, all right? Same 15-foot easement on the north, all right? That didn't exist prior to this legal being created in 2001, all right? What I believe, based on all relative and reasonable evidence, is that there was never an intent to create an easement on the north half of the LCEC lot. They carried over the language from the other deed that was supposed to actually be on the north half of Ms. Farley's lot instead of on the north half of the LCEC lot. Gone back with the title company to discuss this and try to get it removed. There are ways to get it removed, but the bottom line is that it takes, signatures and other things like that. But it looks like it was a mistake. And further, to point out my reasoning for that is, I'll tell you this. So this is the warranty deed for the property that is directly adjacent and to the west of the LCEC lot, right? So directly across the street from the fire station. All right, I'll back up and I'll show you where this one would be. It would be this lot right here, okay? And what's interesting about that is that if you read this, it is subject to a 15-foot easement on the south for road right-of-way purposes and subject to a 6-foot easement on each boundary for drainage or utilities. It's the same language, except it's the south, not the north, which makes logical sense. Why does it make logical sense? Because the roadway on these lots is on the south, the roadway on this lot is on the north, right? So they superimposed or messed up where the easement language should have been. And to that end, even further, Madam Hearing Examiner, what I'll tell you is that this lot doesn't, from what I can tell, and I will acknowledge that I have not run title work on that lot, but I have looked through the public records. I can't find a 15-foot road right-of-way easement up here, so essentially this easement is an easement to nowhere as best I can tell from looking at things. So ultimately, the reason I wanted to point that out is because, as you know, going all the way back to the beginning of this, the reason for asking for the PD is really because of the deviations, right? I mean, ultimately, the uses are allowed, and even in an RS1 zoning district, it's really for a few deviations to be able to kind of build this in a way that makes sense. And when it comes to that easement, especially on the north, it really shouldn't even be there. I believe in my best judgment, and in some of the other real estate attorneys, my law partners that I've spoken to, we all believe that it was created in error. In order to remove it, there are some other steps that we'd have to go through, and it's complicated and it gets difficult. So we're asking for a deviation. So with respect to that, I just wanted to point that out to you. If you have any questions about that specific issue before I move on. Okay, thank you. So again, I wanted to just point out, we provided a copy of this last time around. This is just a rendering of the property. I mean, we've tried to design it to shield everything. The storage is, again, and this is another important point. So we've heard a lot of concern from the members of the public about the current storage going on the lot, rightfully so. I understand how they feel. I think LCEC understands how they feel. We've had conversations about that. It's a residential neighborhood and there's stuff stored on a lot. I understand. The whole point of this is not to allow outdoor storage. It's not a schedule. It's not an approved or an allowed use in this plan development as we have it stated. It would only be indoor storage. The idea being that there would be a garage where everything would be stored inside, so that one of the current complaints that many of the neighbors have would go away. We would be able to put everything inside. You did discuss, and you asked me, I think at the end of the last hearing, you said you wanted some clarification because when we started off, I was talking about the planned and intended use of this property, and you heard testimony about what's going on now. And, I stand on that. The clarification is, look, yes, there has been a lot of LCEC activity on the island. Almost every day there have been for the last several months. They're paying $500 to go on the ferry every day. That is really, as I said before, due to the hurricane damage and the underwater issues that are going on in conjunction with that already planned changes that they had out there to update the electrical infrastructure. We do not intend for this facility to have to be manned on even a regular or a common basis. I can't promise that there will never be a time when there's not activity going on. I don't know what hurricane season will bring this year or next year or any other year. And part of the goal here, again, as stated, is to be able to have an indoor storage area under this garage so that they can store this equipment and material, and they can keep it out of the weather, out of everybody's viewpoint, and not have to barge it over there on a regular basis if there is an outage or a need.
So with respect to that, because that was a repetitive concern, right, is that it was described as a very benign use where it's going to be office. So I guess my first question there is who's going to be using the office? Are you anticipating to have customers coming there? Is there going to be traffic, or is it solely for the operational needs of the workers that are there to conduct the repair work? So that's my first question. Secondly, it appears to me, looking at the master concept plan, that once this is constructed, you've eaten up most of the space where trying to superimpose the photos that I'm being shown of what's occurring on the site right now. It appears like there's some pads or things that have been laid down. I believe that's essentially where this building is going to be. So what capacity is the property going to have to accommodate any of the heavy vehicles that are out there right now, or the larger items that are being stored that are really egregious and eyesores, as you've heard them described? So what realistic opportunity will there be for that to continue after this is constructed?
Okay, so let me try to answer both questions in turn. So the administrative offices, no, the idea is not that the office will be manned on a daily basis. They would be for the people who are out there working on the island if there's a need while people are there to have an office, to have plans or materials that can be left in the office instead of, so there's equipment, and then there may also be documentary materials, things that might need to be stored there, and that's the point of the office. But no, we're not anticipating having people come there to pay bills or anything like that, no. And if there's additional condition that you feel comfortable with on that point, we are not objecting to that. That's okay. Secondarily, to your question about, yes, so the building is taking up the area where the outdoor storage is going on now. If this is approved and constructed, those things, they're just practically speaking, won't even be a place for them, right? That's why we would have the underground area. all right, not underground, under building, enclosed area. You I think understood what I meant.
I do. I just, that is, and understandably, I think we can all understand the concern that's happening right now, right? There, it sounds like there's loud vehicles that are happening on that site, and it's in a residential neighborhood. So your argument is that that's all going to be abated essentially once this is approved and constructed, and I'm trying to get and test the accuracy of that, just to determine what capability would there still be to have some of the larger items that they're having to look at right now, or the heavy equipment.
Well, and I mean, you're correct. And if you look at the site plan, again, and I think you were, right? So, I mean, if you, there's just really not any place for that stuff to continue to be out there once the building is constructed. You know, you've got some buffering areas that we'll have to have around the side of the property, and you'll have a front driveway. But again, that's the reason why it's being enclosed underneath with a garage for storage to get that stuff out of everyone's view, if you will.
Okay. And going back to the operational questions, the number of caretakers residences, I think that came up in the first. Is there any expectation of how many workers that you might have? It's being referred to as workforce housing, not workforce, but workers housing now. And I just need clarification on what's actually being proposed, because there's no condition right now. It just says caretakers residence. So I don't know how many folks we're talking about.
So, Linda, tell me if I've got this wrong, but I don't believe I do. So, it would be 4, is that correct?
Yes.
Yes. So, and that really is based upon, that's, when we have workers on the island, that's typically the number of workers we have on the island, 3 linemen and 1 helper. So that's how we got to that number.
I'm going to let you go, and then I'll ask you questions as I go, because I know I think I'm getting into areas that you might be anticipating to cover later.
So the next thing is, we did hear from some members of the public, and again, the reason I'm showing this rendering once again is that this is the idea as to how we would construct it. And, you know, I'm just showing pictures, and I just went on, I think it was Zillow, and pulled some pictures of houses that are currently on the island to show, you know, the similarity of how we're looking to construct, you know, much of this. And these are just 3 examples. But again, the point being here, I do understand the public's concern, but what we are trying to do is construct something that looks very similar to the houses that are already there, in order to not make it look like a commercial building or even as big as the fire station that's already across the street. That's kind of the point of all of this. I also want to just address briefly, and I'm going to have Mr. Owen come up here and talk about the environmental, because that's been discussed a time or two. But I did want to basically just address a couple of other items that have come up. So, number one, there's been some discussion about the precedent-setting nature of this, right? So it's a zoning action. Zoning actions don't create precedent from a legal perspective. I understand what their practical concern is. The other thing is that it's a CFPD request. The property across the street was rezoned to CFPD, and I believe it was in the earlier mid-90s. It was rezoned to CFPD. So we're not asking, it's not a commercial rezoning. It is a community facilities plan development. The other thing is there's been a lot of indication that LCEC is a for-profit company. That's just flatly wrong. LCEC is a 501c company. It's owned by its members. It's not a for-profit company. It has an obligation to provide services to its members. Ultimately, some of the other stuff, and Linda Miller is going to come up here and talk a little bit about a little bit more the compatibility in that aspect. But I do want to point out, and I'm sure you already know this, but I'm going to point this out anyway, right? So the existing zoning on the property is RS1 zoning. The RS1 zoning schedule of uses in the Land Development Code allows essential service facilities Group 1. That's the use that we're asking for, the primary use. There's a couple other uses. But so as far as a compatibility concern, the code already allows it. So there really is no compatibility concern either under the comp plan or under the Land Development Code because of the already allowed use. This really is only about the deviations. That's pretty much what this comes down to. There's been questions about the Florida statute related to siting of substations. So once again, when I went back and I discussed this earlier on, I did say that the statute allows us to put a substation in any zoning district in any future land use category. It does. I cited that for you. Before we bought this, we did actually have conversations with staff about that. Now, ultimately, the bottom line is that we don't want to build a substation that looks like a normal substation. If you drive through, Cape Coral is a good example, you'll see many large substations that are unsightly, is what I would call them, okay? A big part of this is we don't want to build that on the island, all right? We don't want to build what you would see when you drive through Cape Coral on North Captiva. We do need to put some switching gear due to the new line in this location, but that's why we're trying to build it in this way so that it does not look like a substation, right? It's a more residential friendly type use. It looks similar to what you would see anywhere else. That's in many ways why, and we're trying to kill two birds with one stone. We're trying to put the switching gear in the substation that we need in order to do that in a way that doesn't look unsightly. And we're also trying to provide for some undercover storage, garage storage for the materials that are needed on the island, and allow for a place for the workers to stay at times when they are needed in order to have to not send them back and forth every day. So with that, what I think I'm going to do is ask Paul Owen to come up and just address the environmental questions that have come up. And unless you have any other questions of me right now, thank you.
Morning, Paul Owen with Owen Environmental Consulting. Yes, sir.
Go ahead. Just
Oh.
Can you walk through Mr. Owen, can you just walk us through the date when you did your assessment? I think you've heard some questions from the public about concerns over gopher tortoises and vegetation clearing on the lot.
Sure. So we were on site and conducted our protected species assessment on August 26th, 2024. Saw, and I was there personally, I saw no signs of gopher tortoises, no listed species, no signs of burrows of any sort. In fact, I would consider it very poor potential habitat for gopher tortoises based on elevations and soil conditions. I also went back and looked at the history of the site and what was there, and discovered that the site had been cleared almost completely in 2002. And so what likely happens in that situation most of the time is you get exotic vegetation that grows back, and likely the site was completely infested by Brazilian pepper and other exotic species by the time that LCEC purchased and cleared the property.
But to be clear, Mr. Owen, because there have been questions, so when LCEC had cleared it, and in fairness, prior to you going out and doing your assessment, right?
Correct.
Okay. But despite that, you looked at everything and you did the assessment that was required at that time?
Correct, and didn't find evidence. Usually there's some sort of evidence of it being tortoise habitat regardless of being cleared.
All right. That's all I have unless Madam Hearing Examiner has any other questions.
Thank you.
Thank you.
All right. I'd ask Ray Boss to come up. Mr. Boss, well, I'll let him tell you. He's coming up.
Good morning.
Good morning. Ray Boss, Manager of Facilities for LCEC.
All right, Mr. Boss. So just a couple quick questions here. So it's been described that there's quite a bit of activity going on up there on the island on the part of LCEC right now. Can you sort of describe what's going on?
The infrastructure work that's being done is to replace storm damaged equipment due to Ian and the last two hurricanes, switching out transformers and wires.
All right. There's also been discussion about the use of combustion equipment in order by LCEC. Can you explain why that's happening?
That is correct. Due to the nature of our equipment and the weight of it, battery operated equipment will not lift that. They are significantly heavier than what anything that is electric would be able to carry.
And you've heard me describe a few minutes ago sort of the plan here as the facilities manager, the plan for the use of the property and the difference between the restoration. Is that accurate from LCEC standpoint?
That is correct.
Okay. That's all I had for Mr. Foss.
Thank you.
Okay, thank you.
You want to go next and talk about planning stuff? Compatibility.
Good morning, Linda Miller, Vice President of Avalon Engineering and Certified Planner. As Richard said, the essential use is actually permitted in RS1 plus a lot of the other zoning, actually every zoning district and every land use district. The reason for the community facility PD is to establish those uses. So the schedule of uses is very important and it's very limited for this PD. So being compatible, if you look at what Mr. Forgy said, 26.1, compatibility, the use is compatible because it's permitted in every zoning district. If you look at the building itself, the height of the building and the character of the building looks like a single family home. As Mr. Aiken said, it's not a traditional substation as you can see all through the county. The landscaping will be very similar. The stormwater will be in place, which will actually help the facility right now because right now it's just flowing off into the street. So the compatibility for 26.1 and for 5.1.5 is there. We're providing compatibility. We're across the street from the fire station and we look very similar to other developments in this. And just as Mr. Aiken pointed out, this is a community facility plan development. It establishes a specific zoning district for these uses. It's not a commercial development, and this is not increasing density.
So just on 5.1.5, you mentioned it, but as Mr. Forey said, it was not in the staff's evaluation. Did you evaluate compatibility through 5.1.5?
Yes, I think I did that in my letter of intent.
Okay. And you talked about 26.1 and 26.2.3, that was cited as well about the concern for permitted heavy construction equipment. And did you look at that policy as well for the vehicular use?
Well, I think I went through all of the policies definitely, and this is a temporary. The work is temporary. When the work is done, those equipment will be taken off of there. There's some equipment that will be stored, but they'll be stored in the garage.
And even so, I think that was my question, because it exempts emergency events and public purposes and approved community needs. So I just didn't know if you had evaluated which of those you were seeking protection under.
Well, I think that we're right now under emergency for repairs, and this is a use that is a public need for improvements and upgrades and equipment.
And hold on, Ms. Miller, if I could just ask.
Sure.
So the community need, I mean, in fact, it is defined as an essential service facility, is it not?
Yes, yes, it is.
Thank you.
Okay.
Before you get to the next one, the architectural limitations keep coming back, that it's going to look like that, but there's no condition. Was there any discussion to condition approval to address that? Because I don't think the community standards require or impose anything.
No, they don't. So we did discuss it on our side, and I can discuss it further. If you would like us to propose something to you, we can do that. I do think, I'm not sure that it is. Well, there are already obviously height requirements. There's the setback requirements, and so as far as the architectural standards, we can take a look at that and try to propose something to you that makes sense.
I think it would be appropriate. I don't think that you need to append any kind of a illustration. We got away from that years ago in the zoning, but I do think a condition, because it isn't addressed in the community standards, just because all the discussion keeps coming back to this assurance to the community that that's going to happen, but there's nothing actually in the documents that require that. So that would be a condition I would like to see maybe some work on after the fact. But again, I don't think that has anything to do with the next witness you were about to call, but I wanted to take the opportunity to ask the question now.
No, that's fine. Thank you, and we will work on that. All right, so next I'm going to ask Brendan Sloan, who was previously recognized as an expert in this hearing, just to briefly talk about the septic, because I know you have a couple of concerns there, so I want him to address what's been done.
Thank you.
All right, good morning, Madam Hearing Examiner Brendan Sloan, Avalon Engineering Vice President and Director of Engineering. So to address the septic, so obviously the area septic systems are standard. And on this site, we have hired a septic specialist to take a look at the flow requirements, and There was a way to design the septic system to meet the requirements. It would have to be permitted through the Department of Health and through Lee County as part of the development order in the next stage of this. And as it's a requirement already, if you wanted to put a condition on this approval that the permits have to be in hand to start construction, we're happy to have that.
Thank you.
Okay.
I think that the other questions I had were addressed earlier on that matter.
And Madam Hearing Examiner, if you would like us to draft a condition relative to the septic, I can add that as part of the other. I'm thinking that, in the event that LCEC decided not to construct the caretaker's residences, I don't think it would be necessary. But we're going to have to show that in development order plans anyway to get the permit, so.
Thank you.
All right, so the next thing I wanted to address was, there was a question by, it was the gentleman who was the real estate agent, and I don't remember his name, I do apologize. But he talked about mud. I think he said mudded up a couple of times, which I just wanted to point this out. So there's been two different minimum use determinations issued by the Lee County for this site. So one was back in 2001, and then another one was in 2016, and the numbers are there for you. I don't really think that's really an issue. I just wanted to address it since the members of the public, at least one, had raised it. So I think that pretty much addresses what I had on rebuttal. I think we've gone through most of the things that the public had. If there's something else that you specifically have a question on or that you don't think we addressed, I'd be happy to go through it.
The only other item that I think I had asked for clarification on at the end of the last hearing was the stormwater berming. A lot of the folks that spoke that were in that area had concerns that this site's construction would negatively impact the flooding they were experiencing on their property.
Mr. Sloan will come back up here and address it for you. Thank you.
Thank you.
Brendan Sloan, back here. Okay, so as far as stormwater goes, we will be required to design it to prevent discharge into the neighbor's property. So as I stated in the last hearing, we will be required to do water quality and nutrient loading treatment. For the site specifically, from a rainfall perspective, we are going to hold that water back to the 25-year storm stage and not discharge it prior to that. So as far as the ponding goes, what you saw is a picture of a pre-condition. The post-condition of the site would have a berm around it that retained water on site prior to the discharge of that 25-year stage over a berm top, so which is allowed by the South Florida Water Management District code requirements and Lee County. So,
Thank you.
All right, so Madam Hearing Examiner, the only other thing I would like to do is provide you with a copy of these additional rebuttal slides because they were not in our original presentation.
Yes, thank you. So that'll be applicant exhibit 5. Does that include the, you made reference to one of these meetings that you were going to provide me as well? I'll append that and just make a composite exhibit for 5 as your rebuttal slides.
Slides from December 2021 that was a meeting, an informational meeting regarding the...
Correct. It wasn't site-specific, but it was about, correct, okay. Thank you. All right, whenever staff is ready. Good morning.
Good morning, Sharon Badamchian from Lee County Zoning. I'm just gonna talk briefly about the reason why staff recommended approval. The reason for it is the use they are asking is already permitted in RS1. So when the use is already permitted, it's hard to deny when they are asking for a planned development because of the buffers, and the buffers issues are all because of the easements they have. And for that, Mr. Fergie talked about policy 1.4.2, saying that the lots have to be 1 acre in size in the area. Well, there aren't that many 1 acre lots in the area. They're all legal, non-conforming lots of record. And he also talked about policy 5.1.5, which talks about protecting residential uses from destructive use. And he was absolutely correct when he was reading the policy that says request for conventional zoning will be denied. That's another policy. But the policy doesn't end there. It goes on and it says it can be approved as planned development with appropriate conditions and deviations. That's why we have a zoning CF1 and CF2, which CF, which basically allows the use, which is already permitted, but we went with planned development because of policy 5.1.5, which says they can be approved as planned development. And staff added conditions for approval, but after hearing people, you are more than welcome to add any conditions you want to. I'm sure you're gonna have some conditions, which is, I think is appropriate, like the design of the building or landscaping or buffering or what have you. And with that, staff still recommends approval because the way the code is, the use is already permitted. So even if this thing is denied, they can build it. That's all I have to say.
Thank you.
Thank you.
Okay, so then yes, I would like some conditions, if you guys can take a stab at working on those for the architectural standards, septic, and any buffering landscaping, as you just noted. So I'm not sure how much time you guys would like to do that, given that we're at the end of the month now already in July.
Yes, Madam Hearing Examiner, and I'm going on vacation tomorrow for a week. So if we could have maybe 2 weeks to get that done, I would really appreciate that.
Most certainly. So I'll make it until end of business on August the 8th, just for those revisions or additional conditions. And then for anyone that is here, thank you again for coming. Thank you for sitting through all of this with us, and thank you for making the trip down. You will receive a copy of my recommendation if you spoke, and anyone that completed a card will do that as well, with the information of when the final meeting will be before the Board of County Commissioners. And again, if you spoke at this hearing, you're welcome to speak at that hearing as well. So thank you, everyone, for coming, for your time. And please stay well and enjoy the end of your summer. Have a wonderful weekend.